Welcome back to part two of day two of the IIC's 51st annual conference, kindly sponsored by Frontier Economics. I'd now like to introduce Anne LaFrance, IIC Vice President and partner at Squire Patton Bogg, and also moderator for our highly topical discussion on the latest privacy, cybersecurity, and data localization issues in different regions. Over to you, Anne.
Thank you very much, Lynn. It's a pleasure to be chairing the Data Privacy and Data Protection Roundtable today. Also a challenge because 2021 has seen a number of very important developments that I think we'll struggle to find time to cover, particularly since the tech and telecom sectors are really at the intersection of most of the developments that have been happening in the world. Let me just run through a few of them by way of introducing the topics and the panel today. I think this has been a year when the GDPR's horizontal privacy model has really taken root well beyond the countries outside of Europe where we might have expected it. We'd already seen Brazil, but nobody was really expecting Colorado and Virginia to be talking about controllers and processors, and yet they will be. Also, California has enhanced its CCPA and will be implementing the CPRA, which comes even closer to the GDPR. And then we have China, which has adopted the PIPL, which is similar in many respects to the GDPR, different in some significant respects as well. At the same time, including in China, we see data localization arising or continuing to kind of proliferate with some of these as a byproduct of some of these privacy laws, but also in some cases as a direct sort of part of it. And of course, we have the famous Schrems II decision, which as a practitioner in this field, I can tell you, has caused a global paper chase of unknown proportions, I've never really seen anything quite like it, which is excellent for lawyers, but I do wonder, I think the world is wondering what the practical impact of it will be in the end. Questions continue to swirl in the major democracies around the use of metadata, message content, online tracking apps, and other forms of electronic profiling or surveillance, however you'd like to call it, by the private sector and also by government. And when I talk about government, I'm talking about it in its law enforcement and national security roles, governance roles, and also political campaigning. Now, how these vast amounts of data about individual humans are being aggregated, analyzed, fed into algorithms, and used to expand the attraction and reach of the existing powerful digital platforms is obviously a major policy focus as we speak. And there are, in my view, no clear solutions. But while our attention is focused on the here and now, I worry that there may be many new under the radar platforms that are developing or business models that are developing based on AI and other powerful technologies that we may be missing. So these are issues that are complex and difficult and challenging. And there is just no silver bullet solution to any of them. Moving to cybersecurity and data protection, it's also been a year of proliferating and increasingly damaging ransomware and cybersecurity attacks, affecting both the governments and private sectors. This just mentioned SolarWinds, Colonial Pipeline. Experts have estimated that the increase in the number of ransomware attacks this year alone has been 400%. With escalating demands and human impacts, including now deaths. So finally, let me just not forget that we have been enduring the impacts of the pandemic, and the pandemic has had its impact on privacy and vice versa as well. I think the pandemic and the way we've dealt with it in different countries and in different contexts has made it abundantly clear that balancing the public interest with privacy rights is a very complex exercise. And the outcomes often depend on ingrained cultural norms at the national level, at the regional level, and the local level. these are really complex issues, as I said, involving complex technologies, complex business models, and complex solutions. So here to help us delve into these areas and other issues that we will be talking about is a panel that spans the globe, the government, and the private sector, and both tech and telecoms, very IIC type panel. First, let me introduce, and I'll just go through the list now, and then I'm going to ask each of the panelists to give a little bit more background about what their remit is so that you have a good understanding of their focus. Just to quickly introduce the panel, we have Thomas Zerdick, who is the head of unit for technology and privacy with the European Data Protection Supervisor. I'm hoping that we will have Professor Sizwe Snell Kamtuzi, who's a member of the Information Regulator of South Africa. We spoke yesterday and he had some really excellent contributions to make, but we're having a few technical difficulties, so we'll see if he's able to join us. Ivana Kriznik, who is head of public policy, Canada, Latin America, and emerging markets for Verizon. Sarah Nasrullah, who is legal counsel for privacy at Bell Canada, and Robin Green, privacy policy manager with Facebook. So without further ado, let me hand over first to Thomas to give us his perspective on some of these topics and let us know what's across his desk these days. Thomas?
Hi, Anne. Thank you very much, and thanks to the IIC for the invitation to speak to you today. What is the EDPS? What's the European Data Protection Supervisor? Well, we are the independent supervisory authority for all European Union institutions, offices, bodies, and agencies. What does that mean? We are the ones who supervise, for example, the European Commission, or the European Parliament, or the Council of Ministers, or agencies such as Europol, the European Police Office, or our cybersecurity agency, ENISA. Those EUIs, as we call them, comprise approximately 50,000 people. Our European Data Protection Supervisor is called Mr. Wojciech Wiworowski, and he and me and the staff, we are counting approximately 120. We have three main activities: supervision, legislative policy advice, and technology. And I'd like to share with you 4 top topics we're dealing with as we speak. The first being as regards supervision, the obvious, you mentioned already, Anne, Schrems II compliance. So what does it mean? We have started investigations into the use of products from Amazon Web Services and Microsoft, for example, from our EU institutions into cloud services and under contracts used by the EU institutions, and in particular on Microsoft 365, to gather and understand how are these contracts compliant with the Schrems II interpretation. Obviously, this is triggered, as I said, by the Schrems II judgment and by the problem of third country government access to data stored and processed in the EU. So what we see, I can share that with you because we've made that public. There are still numerous problems with Schrems II compliance. We also see language and contracts which is not in line at all with GDPR provisions. So obviously, one way to counter that, the best way to comply with Schrems II is not to transfer any data outside of the European Union. The second topic is digital sovereignty, and you've mentioned it again. Because of the pandemic, we've seen so many people starting to accelerate the digital transformation, and our EU policymakers have realized that here in the European Union, we are dependent to a large extent on products, tools, and services from other parts of the globe. And they have realized that that dependency might not be the ideal thing, in particular when these products, tools, and services are not in line with, for example, data protection rules from the EU. This is what we see. As you know, data protection by design, privacy by design, is now a legal obligation in the EU thanks to the GDPR. And that means we and everybody has to look at these tools, products, and services to check, are these products in line with that? But that means also we, as the European Data Protection Supervisor, for our own purposes, we are looking now at alternative providers, alternative tools, because we believe that those alternative products might even be more data protection friendly. We're talking even about alternative social media. The third topic, which is really big for us at the moment as legislative advice is concerned, you know that the European Commission is obliged to consult with us when they're proposing new legislation, and that if that legislation has an impact on data protection, we will give an opinion. And we have done that in particular as regards the proposed artificial intelligence regulation, together with our colleagues from the European Data Protection Board. And in this opinion, which you can find online, we as European Data Protection Supervisory Authorities, we welcome the risk-based approach, but we clearly ask for a general ban by any use of AI for automated recognition of human features in publicly accessible spaces. So not just facial recognition, we're asking for a general ban of recognition of faces, DNA, voice, keystrokes, whatever you have. Happy to discuss that later. And then last but not least, what am I doing? What are we doing in my unit? That's technology and foresight. We believe that in order to understand data protection and in order to be able to supervise and advise on personal data protection, we need to understand the underlying technology. And that's why we have launched two initiatives, Tech Dispatch and Tech Sonar, all free of use for you to download and to subscribe. The Tech Dispatch is a technology description where we go into detail and describe, for example, what is facial emotion recognition and what impact might this have on data protection under the GDPR and our legislative framework. Or the Tech Sonar, where we have established a process inside the house with technology experts to have an understanding of what might be the next technologies to monitor in the next year. We have come up with 6, again, you'll find them on our website, for example, synthetic data or just walkout technology. So those are the 4 hot and topical issues at the moment at the European Data Protection Supervisor. I'm looking forward to the discussion. Thank you.
Thank you very much, Thomas. I think that we now have Professor Sizwe Snell-Kamtuze with us. Is that right? Sizwe, are you with us?
I am, ma'am.
Oh, that's excellent. Hello and welcome. I've turned it over to you to give us the background on what is happening in South Africa.
Thank you for the opportunity to your conference and to give you a position of the South African position relating to data protection legislation as we have it now in South Africa, as well as the developments, in particular the developments of the last 3 months. For those of you who may not know, we have a data protection law in South Africa called the POPIA. That is the Protection of Personal Information Act. It was drafted in the early 2010s, 2011, 2013. It went through various legislative developments. It was passed into law in 2013. So it may be seen as having some of the older principles relating to data protection. I mean, as 2013, we already know that there already was a traction towards the principles that we now have in the GDPR. So you can accept that although it's a 2013 act and we haven't had any legislative changes ever since then, when it did come into law in 2013, it really considered all the international best practice relating to data protection, as well as all of the international developments that were taking place at the time. And I'm mentioning first and foremost the GDPR. I remember when the information regulator first opened its offices, we were literally in the offices of the Department of Justice. We were given a boardroom, and within 6 months thereof, the grace period was ending of the GDPR. And it was very interesting to know that what we are trying to develop as a DPA is currently already taking place in Europe for the last 30 years. So it's really been a paradigm shift in attitude, a paradigm shift in terms of constitutional law. You will appreciate in our South African law, we also have the right to privacy entrenched. So the need for data protection legislation didn't just come because of what is happening internationally, but because to enjoy the embodiment of certain human rights, and I'm specifically going to use the word human rights because privacy is a human right. Our law in certain instances requires that legislation be put into force to clarify that right. And I think the POPIA has really clarified the right to protection of personal information. It has made us as South African citizens aware of the right to protection of personal information, the sharing of data subjects' personal information by social media companies. That's been a very hot topic at the moment that the regulator is dealing with. Aspects relating to direct marketing, intersections between, let's say, competition authorities, as well as, the data protection authorities. And I think what's most important in the last 3 months, from the 1st of June, is the fact that you can complain to the regulator about the abuse of your rights, and the regulator now must investigate, must make a decision, and when necessary, enforce the decision without you having to go to a court of law. So I think that's a bit of a taste of what's happening in South Africa in terms of our data protection law. I think that will be it for my introductory talk. Thank you very much.
Thank you, Sizwe. We've now heard from the regulatory side of the House, or the regulator side of the House, and moving now to the private sector. Let me ask Ivana Krisnik from Verizon to give us the perspective from the emerging markets plus Canada that in Latin America that she's dealing with. Ivana?
Hi, Anne, and everyone. It's great to be here. I'm with Verizon International Public Policy. Most of you in the US, I guess, will be familiar with Verizon, where we are one of the leading providers of telecommunications and technology services, and we are a world leader in 5G. Perhaps people outside of the US, they are not that familiar with Verizon. And the reason is that outside of the US, we provide global connectivity to enterprise customers. So we don't have a consumer business or a wireless business outside of the United States, but we connect global enterprises through private networks, internet access. And I think it's interesting to bring to this panel perhaps the perspective of a global connectivity provider in the enterprise space. And the services to enterprise customers, that business is very different from the consumer business. And I think that's an important perspective when we talk about privacy. One thing that I want to sort of share with the rest of the panel that has been what has kept me busy lately is the discussion on data flows that is related to privacy and comprises some of the discussions on privacy and security, but also goes a little bit beyond that. And I think we are sort of at an inflection point, perhaps, in terms of data localization and data flows. And we are seeing two conflicting trends. One is in the last few years, we have seen an increase in government policies that are attempting to impose data localization requirements or restrict cross-border data transfers, or even do some sort of adding up too many restrictions and then resulting in a de facto restriction or localization requirement. And what we are seeing is that it's targeting different type of data, not only personal private data, but also other sort of broader categories of data that is deemed important or sensitive or critical. And it's also going beyond perhaps a discussion on protecting privacy rights and going into more sort of ideological perhaps areas of cyber sovereignty, cyber colonialism, even censorship in certain cases. So that's one trend towards an increase in data localization requirements. On the opposite side, we are seeing a renewed commitment at the international level at forums like the G7 and the G20 and the OECD, and in the new trade agreements like the USMCA and the Trans-Pacific Partnership, the recent DPA between Chile, Singapore, and New Zealand, where all these countries are coming together to talk about the digital trade and the basis of that, which is really data flows. So perhaps if I have a minute, I want to maybe get a little bit more into the details of what we are seeing in terms of data localization. As I was mentioning, we are seeing regulations around the world that are sort of targeting 3 different types of data. One would be regulations that look at specific types of data. So they would target and say, well, you have to localize like personal data or health data or credit card transaction data or telecommunications data. Then we are seeing other regulations that they are sort of looking at broad categories of data, what they call sensitive or critical or important or call, and that data it has to be stored or processed or used in servers located in a country. And perhaps what is more of a concern is certain regulations that impose so many requirements on data transfers that when you look at that as a whole, you start seeing a system where it makes it very difficult, almost impossible from a practical perspective to transfer data out of a jurisdiction. And why is that so important to global connectivity? If you think of global networks, around all the different countries that I guess we represent in this panel, really these global networks are the basis for data flows, right? We provide this connectivity that connects not only people, but also factories, schools, hospitals, and is the basis for other services that are part of sort of this industry. For instance, IoT, right? When you think about fleet management or all the advancements that we have in the connected space, right? So all those services and networks and infrastructure depend on data flows. And again, not only talking about private data, not only talk about sort of critical data, but talking about sort of everyday data, if you want, like the network connectivity data, the data that we need to operate all these different networks and services. And this is even, I think, becoming more of a concern when you look at emerging networks like 5G. If you see the amount of data that will be carried by the 5G networks, or even these innovative services like the low Earth satellite constellations that are becoming more and more important for many parts of the world for connectivity. So to give you a few maybe data points to close my remarks, there have been numerous studies by the OECD, by McKinsey, by industry groups like the Global Data Alliance or the ITIF about the cost of data localization and how we are seeing increases in the number of data localization requirements in the last few years. So to cite one of the studies by the ITIF, from 2017 to date, we went from 35 countries having data localization requirements to 62, so quite doubled. And if you look at how this is impacting global trade, there have been different correlations for economists, I guess, in the panel that like this, where you see how data localization diminishes the benefits of trades to the countries. And what I thought it was very interesting was a recent study by McKinsey, where they look at the benefits of data flows, and they see those benefits going to traditional industries like manufacturing and agriculture. And I think this put a little bit into perspective the issues, because it's not so much about sort of the big tech or telecom that is being impacted. It's all the different industries, and even industries that are very important to countries where these data localizations requirements are taking place. So I will leave you with one last number. So the OECD estimates that data transfers contribute 2.8 trillion to the global economy. And with that, Anne, I think, if you want to go ahead with the rest of the panel, those were my initial remarks on data flows and data localization.
Thank you, Ivana. Interesting food for thought. I think we're going to have very interesting discussion about this when we're finished with the introductory remarks. Okay, let us then move on to Robin, if that's okay. Robin, would you like to tell us, I guess Facebook has a bit to say about this?
Hi, yes, thank you. And thank you so much for inviting me to speak on the panel. At Facebook, I have a global remit, and so I'm not going to be really focusing on a specific region, but rather sort of looking at broader trends. And my role at Facebook is around policy development regarding anything having to do with privacy and human rights at the intersection of government access to data, data security, and global data flows. And so this is an issue that's really close to my heart, and I'm so glad that folks have already been talking about the important role that data flows play in the global internet. The reality is the internet's the most powerful tool ever created for giving individuals and communities control over their lives and their futures. It's instrumental in advancing democracy and human rights like privacy, freedom of expression and opinion, access to information, and online assembly. And it creates economic opportunity around the world and enables communities to actually safeguard their rights and hold abusers to account. But one thing that I have been seeing is a really worrisome trend where governments around the world are basically considering draft laws and regulations that drive internet fragmentation. And this enables them to engage in widespread surveillance and censorship, such as regulations that require or result in forced data localization, encryption backdoors, personnel localization, and also blocking of websites and major social networks and platforms. And ultimately, in many cases, these policies undermine the very goals that they're intended to address. So data localization, I think, is one of the best examples of this. A narrative has actually taken hold in a lot of the countries where we're seeing data localization under consideration, where they're looking to China's success in the global tech economy and seeing that as a direct result of the protectionist measures like data localization mandates, and basically assuming that if they adopt similar protectionist measures, that they would be able to reproduce those same kinds of results. But really the assumption that you can reproduce those results, it elides the fact that China's tech economy developed with these kinds of constraints in place at the start of the digital revolution, and so it sort of grew up with them. And conversely, many of the countries that are now considering adopting these kinds of measures already have large and growing digital economies, and those economies were built on the globally connected internet infrastructure. But the problem is most people and businesses, and by extension, really tech and tech dependent or like tech enabled companies that have flourished in these jurisdictions, don't actually realize that almost everything we do online, and in many cases, a lot of the things that we're doing offline in our daily lives actually depend upon the ability to transfer data across borders. And so one of the things that I'm really concerned about is that if governments do mimic China's approach by adopting data localization requirements or other impediments to the physical transfer of data across borders, it would be like trying to put toothpaste back in the tube in those jurisdictions. It's just not going to work, and countless studies with like economic data and statistical modeling have shown that. But the reality is internet users are going to pay the added price on top of the economic harms of losing protections for their fundamental rights. And one of the places that we're seeing this is because a driver for data localization, in addition to sort of economic growth, is often controlling data flows as a means of, or a lever of, enabling the government to engage in surveillance and censorship of citizens' online activities. So we're actually seeing governments mandate these kinds of requirements in order to, for example, compel providers to produce users' data to local governments under the idea that if you establish territoriality, you can assert local law more effectively. And this becomes very dangerous, not only for providers who are committed to protecting the fundamental rights of their users, as Facebook is, but also to the users themselves. And so I think, you know, one of the things that I'm really worried about is seeing how this is sort of driving forward. But I would be remiss if I didn't mention that one of the other sort of related trends that we're seeing is de facto localization. And this is where data localization essentially results from an inability to transfer data because providers can't meet preconditions on conducting those data transfers that are required, most often due to conditions outside of the provider's control, like conflicts of law. We most commonly see these kinds of preconditions show up in the context of privacy and data protection regulations, and they're intended to protect privacy. This is a critically important goal, and it's really something that I think we need to think hard about how we go about doing this, because at the end of the day, it's not necessary to engage in any kind of data localization or restrict the free flow of data in order to protect privacy. Privacy rights attach to the data subject. And so it's, in a way, it's actually not necessarily relevant or determinative where the data is stored. And so data localization is actually not necessary for internet users to gain autonomy over their data. At the same time, though, you see really significant economic impacts. And very concerningly from my perspective, and I think from an increasing chorus of human rights and digital rights organizations, is that all forms of data localization impact human rights. So as an example, Freedom House found in its paper on the human rights impacts of data localization a few years ago, and actually reaffirmed in its last two Freedom on the Net reports, and the Center for Democracy and Technology also noted in a blog post what the risks of data localization are. And CDT, for example, noted that even when well-intentioned, restricting data flows puts the right to privacy in tension with and actually undermines the rights to free expression, online assembly, and access to information. And that doesn't even get to the way that it can impede the exercise of a lot of economic rights, which are guaranteed under human rights instruments like the ICCPR, the EU Charter, and other kinds of regional and global treaties for human rights. And so governments are increasingly sort of looking to data protection as a justification for data localization for both good and bad means. But what we're seeing is that tethering data flows to data protection and other sort of regulations by incorporating express data localization requirements or restrictions on data transfers is posing an immediate and growing threat to this wide range of human rights. And so, you know, I'm sort of looking at this when I think of it through the regulatory lenses. the choices that we make today about how technology companies, data and digital technologies will be regulated will determine whether the global internet survives or if it splinters into local and regional silos that in some cases can actually be controlled and surveilled by rights abusing governments, and whether it really fails to manifest the social progress and the tremendous economic opportunity that an open, secure, and free internet enables. So I hope that, last year was sort of the year of data localization. I hope that this coming year will be the year where governments really work together and in consultation with civil society and industry experts to harmonize differing approaches to internet governance and really agreed upon a shared understanding that ensures fundamental rights are protected around the world and guarantees the free flow of data across borders.
Thank you very much, Robin. I think we'll see now if Sarah has been able to work out the technical difficulties. There she is.
Hi.
Over to you, Sarah.
Thank you. So as some of you may know, I am a privacy counsel at Bell. Bell is one of the biggest telecom in Canada with millions of customers across Canada. Needless to say, we have a lot of PI, whether we are as a controller or a processor. We mostly have presence in Canada, but we also have some enterprise B2B relationships in the US and Europe. So some of the biggest issues that have come our way recently have been those of simply of uncertainty due to the rapidly changing global legislations. As we all know, there's GDPR, there's new legislations cropping up in the US states. Even within Canada, on a federal level, the government has proposed a new bill, and then elections were called, and then it got halted. And now, since we have the same government back, we're expecting that the same bill would be revived, but maybe by the end of the year or the beginning of next year. And then provincially as well, there's been a lot of activity. So I think, and within this activity brings with it some uncertainty, because when we are dealing with vendors and different types of vendor relationships, we have to wonder, today we're locking into an agreement for the next 5 years. But what is the law going to be in the next 5 years? Are we locking ourselves into something that we're going to regret, that is going to be, legislated against 2 years from now? So there is all of that burden on the organizations and their compliance departments to think not only about the changing laws and which jurisdiction, but also where it's going to go and which direction it's going to go in. So there's some kind of guesswork going as well. Bell has like thousands and thousands of vendors. So we have to do this on a daily basis to determine what protections we're going to put in our contract, how are we going to protect our data, and especially in which jurisdiction. So for example, one of the things that we think about is that obviously it's pretty clear if our data is in Europe, we know that there is that certainty around GDPR and having a DPA around there. But within Canada, we have to, sometimes think about getting, should we have a Canadian DPA? Should we have a PIPEDA-based DPA, a Bill C11 based DPA? What about the US? What extra protections do we have to put in if our data is going to the US? These are all these questions that we think about on a daily basis as in-house counsel to one of the biggest telecom. And also, like, how do we future-proof it, and how do we make sure that going forward we are complying with the different various laws that might come into effect? And not to say anything about the thousands of contracts we have already signed. So we also have to kind of go back and look under the hood and see what have we agreed to in the past and whether that's still relevant or not. So these are some of the issues that I deal with and my team deals with as at Bell in a big telecom, as I'm sure that the rest of the private organizations are as well.
Thank you, Sarah. I don't see any questions in my box yet from the audience, and I hope we will get some. Please feel free to use the Q&A because we'd welcome questions, but I happen to have a few questions in my back pocket. And I think maybe we should just jump right into a Davos-like discussion here about globalization and data flows and what is driving what. is globalization still driving data flows? Is globalization in sort of moving slightly in reverse due to developments over the past several years? And is interoperability going to be possible over the next, say, 5 years, given the very different regimes that we are dealing with from the United States to China to Europe and all of those in between, and let's not forget Russia. So I'm not sure who would like to go first on that among the panelists. Robin, would you like to give it a go? Because you kind of raised that whole issue about, you know, the cost of losing a sort of globalized approach. I can just say that since I'm an old lady, I go back to the days when we used to have telephone networks that were connected, but were, you know, local, effectively national. Is that such a horrible thing?
So this is such an important question, and I'm so glad you framed it that way, because the answer is no, it's not a horrible thing to have nationalized telephone networks, but it's very different to have that kind of structure for the internet. And one of the reasons for that, and this is sort of also getting to the question that you asked sort of before about, is are data flows driving globalization, or are the restrictions on data flows sort of causing globalization to recede or you know, walk back some? And so the reality is that the answer is yes to both. And the reason for that, and the reason why it would be hugely problematic to try to nationalize or even regionalize internet networks, is because that's not how the internet was built, right? The internet was built in order to connect people all over the world. And at the end of the day, even where you're looking at having a telephone network where you have a nationalized network, there's still interconnection points, right, that enable you to call someone from, you know, your home in the US to a friend or a family member in France, or, you know, in any other country around the world. And so when you look at that, that becomes a transfer of data. And so even your nationalized network is still interconnected in much the same way that the internet is, except the internet's like hardware and logical layer that actually create all of these interconnections, it's far, far more complex. And so what we wind up having is this system where you have this globally connected network that doesn't even transfer data, physically transfer data in a sort of like shortest from point A to point B kind of way. So for example, you know, me speaking to you right now, still in the US, that conversation could actually go through network switch points in South Korea, in the UK, all over the world, simply because it's not the shortest route for the communication to transmit, but it's the fastest route. And so at the end of the day, we have this hugely complex sort of network of networks, which is essentially what the internet is. And when you start siloing that off, you not only cut off people from being able to connect with one another in really like efficient and effective and impactful ways online, but you also actually cut off all of the productivity that comes with those connections, and you impose significant costs, not only on sort of the companies that build the network infrastructure that would then have to completely re-architect that infrastructure, but you also impose significant costs on all of the other companies and individuals who rely for, you know, work, for social connections and things like that on the sort of interconnected nature of the global internet. So yes, data flows do promote globalization, but we'll see that walk back as a result of data localization and suspensions of data flows. At the end of the day, the harms are far more significant than any potential gains, particularly for people who are living in jurisdictions where the governments don't provide robust protections for privacy, free expression, due process, where discrimination, torture, arbitrary arrest are problematic, because as I mentioned, one of the main drivers of data localization for some governments in the world is to be able to increase surveillance of their populations and assert control over those populations by controlling the internet.
But Robin, I have like a conflicting point of view, is that we all know that there are governments around the world that are abusing human rights. So shouldn't we be cognizant and protective of our data? I would say that we would not want to send our data to those countries which have an abuse of human rights records, or where we know that our data will not be given comparable and adequate protection.
And this is exactly, if I may chip in from the EU perspective, this is exactly what our highest Supreme Court in the EU has said with the Schrems II judgment, that there are data transfers which shouldn't happen outside of the EU because there are specific government practices from third countries outside the EU which simply do not comply with the European way of doing things. And that's why the Schrems II judgment, which Anne has mentioned before, is on all our minds, because that actually means we, from an EU perspective, have to check and look at every country outside the EU to see what's happening there and if data can actually flow. That is, of course, different from the infrastructure, the internet as such. This is about concrete, specific data flows from one controller to somebody else. So yeah, I'm with Sarah on this one.
So I would just offer a slightly differing view, unsurprisingly. But I think, one of the key things to remember, and as I mentioned before, the privacy rights that you get in data protection laws like GDPR are attached to the data subject. And so where data is stored is not determinative of whether a provider is obliged to provide those protections. And so at the end of the day, it is up to the provider to meet those standards. I think the problem that we have when we start saying, well, but we need to limit data transfers because laws in other countries don't meet our standards, it sort of operates under the false premise that if you store data in a country, it can be accessed by the government, which is not necessarily the case. Indeed, many data transfers result in storage because they're direct person-to-person or company-to-company transfers that people are choosing to engage in, but that law, either knowing the risks with regard to jurisdiction and things like that, or that, at the end of the day, there's just not a huge risk of government access because the information's encrypted or something like that. I think the other problem, that we run into, though, is this idea that governments are only going to seek to access data if it's within their jurisdiction. And one of the things that we have seen in particular as a result of all of the news around the NSO, Pegasus exploitations and things like that, is that if a government doesn't respect fundamental rights, they're going to be using those kinds of tools to be able to access data. And so what we do by suspending data flows is actually render the people who are the victims of that government oppression and abuse more unable to fight back because they cannot benefit from the global connections that they would otherwise have when they can reach out to resources and people in rights respecting countries and build global coalitions in order to promote democracy, to promote stronger privacy, to promote free expression and freedom of religious belief and things like that. And it leaves them less able to build the sort of economic power that they may need to make themselves independent from those kinds of risks, human rights risks. So I understand where folks come from when they say, oh, we shouldn't be transferring data abroad because if the government doesn't protect data sufficiently, then we don't want it there. But I don't think that actually aligns with how, in a technical sense, data storage works. In a practical sense, how data transfers work, particularly transfers that are not data center to data center, but are instead just actually the functioning of communications on the internet. And I do think that, and I'm very worried that it actually winds up isolating the people who are most at risk and who are most in need of those global connections that the internet can offer.
I think that, so in almost all the contracts that I've worked on, there's always something about compelled disclosure. So say my data was stored in a server in a different country, and even if it's encrypted at rest in that server, and there are all the technical protections in my contract to keep it secure and not give access to the government, I do think that since the servers are in that country, they will have to abide by their applicable laws as well. So if the government had a subpoena or compelled disclosure, I think that there are very high chances that they would get their hands on the data. So I do disagree here that I get that it might be encrypted, and generally speaking, we may not be giving access to the government in that country, but I think governments are strong and powerful enough in some cases to just get their hands on the data if they want to.
But
you're also talking about data storage, right, and not data transfers. And so there are a lot of different technical things that you can do from a storage perspective to make sure that data is secure. The concern that I have is around the idea that you can't transfer data. You're going to be cutting people off from the connections that they have with one another around the world. If you say you have to, locally store and process data here, and you can't transfer data abroad. And I'm just not sure that those are the same things. And I'm not sure that limiting data transfers is a solution that's well tailored to the problem. And it would be much better for governments to come together and actually agree on what, rights respecting standards are, and have more of a global standard for how to protect privacy and fundamental rights. Much like what's happening right now at the OECD with the working group that's seeking to develop principles on government access in order to protect the global free flow of data.
I think from an African perspective, interesting, because as Africans, we are usually the consumers of services in the country. For instance, if we want to use Facebook, it's an American company, want to use Twitter. For us as Africans, the concern about transfer of data is more about, is our information safe in those data? And we've had years, if not centuries, of information abuse. And I don't think the inventors of the internet thought the sources of invasion of privacy, and I think it's for that reason that legislation there in place to protect use of infrastructure in foreign countries to say, look, the laws that prohibit abuse of data, at least let us be comfortable and have some standard of data protection to ensure that data is not abused. So I'm all for all inclusiveness. I'm all for the global interconnectivity. But the whole interconnectivity argument never foresaw that it would actually be the breeding grounds of personal information.
Thank you, Sizwe. We had a little bit of difficulty hearing you. You were breaking up a bit, but I think we got the gist. Does the South African PIA law have any kind of data transfer limitations in it? Oops, I guess that may be another, here.
I'm here.
You're back, okay. Yeah, maybe without video, you can.
I'll switch to camera because I see
that's better. Mm-hmm. So I was just wondering if the PIA law has a data transfer limitation.
Yes, the PIA it talks of adequate data protection laws or binding corporate agreements in terms of which, that company guarantees you that they afford data protection to those who use their service. So there is a limitation on transfer, and in fact, the limitation is more protection of the data subject.
Okay, thank you. You're still cutting out a bit, but I think we got the gist. Thomas, did you want to respond?
Yeah, I think it's let's call it this. There is a difference to be made, I believe, between what governments and public administrations need to do and the general question of data flows, yes or no. At least here in the European Union, governments and public administrations have a duty of care to work in line with the law. Now, the European data protection rules say, for example, you need to minimize the use of personal data, and you can only process really as far as necessary. And that means, if you read it concretely, for example, if you have a product which is processing less or no personal data in comparison to another product, then public administration should and are legally obliged to use that product which uses less or no personal data. And it's the same way that you can argue then, if you have a product or solution which does not transfer personal data out of the EU and therefore does not expose that personal data and the individuals which are behind it to the risk, the possible risk of government access to their data, etc., that is a preferred way of dealing with the issue. So again, I believe the European rules on data protection are actually pro data transfers, but under certain conditions. And as I think, as we heard from South Africa, there's a similar idea. Data transfers, yes, but in compliance with the underlying values and ideas.
If I may add, I think this might be a pertinent time to just talk about the Canadian past few years, is that they've also gone back and forth on this issue. So for example, initially the regulator said that you can do data transfer as long as the data subject is notified. Then back in, I think around 2017, they said notification is not enough, you must get express opt-in consent. Needless to say, there was a big outrage and a hue and cry, because that would have just been impossible for companies to go around getting consent. And even from a data subject's perspective, I'm not sure if I would want thousands of companies turning to me saying, hey, can we do this? Can we do this? And now, so then it reversed its position. It went back to notice is enough. And now in Bill C-11, which is the new overhaul of the federal private sector privacy legislation, they said nothing about data transfer. So I think that's just the Canadian viewpoint, is that it is a big question. There's been a lot going on, and I think they're just at this juncture where they're unsure. But I think the right approach is that you can do it, but under certain circumstances, and to just define those circumstances.
Ivana, did you want to weigh in on this?
Yes, I think this is a very important discussion. For Verizon, you know, privacy and security are at the core of what we do. So that's why customers buy services from us. So for us, the discussion is never about less privacy. But I follow what Robin was explaining, and I also got the impression that there are misconceptions about data localization. And sometimes I have the impression that they want to use data, some countries want to use data localization as a solution for other problems that have other policy solutions. And localizing data from a technical perspective, doesn't it make the data more secure? Doesn't add more privacy to the data? Doesn't change the way that law enforcement in the different countries access data? And listening to Robin, I become a little bit worried too about you know, moving this discussion towards risk to human rights. Quite honestly, you know, other levels of where some governments are looking at data localization for censorship purposes. So I think that's a very worrisome development, I think. What I would say, Anne, maybe going to one of your comments before, that, you know, different countries have different privacy regimes. And I think the question would be perhaps thinking about interoperability. And I was looking today at what the APEC CBPR is doing. And I think we have now 4 countries that have appointed accountability agents. So it's the US, Singapore, Japan, and Korea. And I think in the US, there are a number of accountability agencies. There are sort of companies signing up to that. So if you look at a country like Japan, I think that's a very interesting case where you have a strong privacy law, you have adequacy by the EU, and you have Japan being very active in the CBPR. So that might be, a way forward. The other positive development, I think it's, and I think you were mentioning the new privacy law in Brazil, that I think gives options for transfer mechanisms. And I think that's very important, right? Not to look at one sort of inflexible path, but to open different options for data to be transferred. So again, good work by the OECD on trying to find, best practices for government access to data in different jurisdictions. They're sort of good also, I think, possibilities going on at the trade level, at the WTO, and some of the new digital trade agreements. So I think there are positive trends. I think we are probably at a point where, we are seeing an increase in data localization, but also we are seeing a number of good initiatives going on.
Maybe I think just as a practitioner in advising clients on Schrems 2 and how to do the assessments, particularly with regard to the US at the moment, but obviously that will have to be done with regard to other countries outside the EEA, UK. I wonder, what I've seen is that there's been a very healthy development in the sense that many companies in the cloud space really did not have their housekeeping done very well in terms of who their suppliers and their suppliers and their suppliers were. And I think that one of the impacts of this, not only the GDPR generally, but now this new look under Schrems, has been to really, have everybody take a very close look at who their suppliers and down the chain, who is doing what in that chain. But I do wonder whether ultimately the practical impact of this will change what is actually happening. I think that at least as I see the Schrems decision, the focus is on not just government access to data where there is due process, where there is where the fundamental rights and freedoms of people can be addressed in a regular proceeding, like a probable cause warrant that might issue. The problem is really with the so-called FISA 702, which has some challenges around due process, depending on your perspective. So I just wonder, if that standard is applied across the world, even to some of the so-called adequate countries, how will Europe effectively be blocking itself off? How will this actually be implemented in an even-handed way if, one of the countries that is supposed to be and hopefully will remain a beacon of democracy isn't even adequate? Thomas, I don't know how will that be reconciled? And I also wonder what is happening with the adequacy decisions. The ones that were agreed prior to the GDPR, is that moving forward? I saw in the communication from the European Commission, there were lots of discussions going on, but I haven't seen what's happening in that area.
Thanks, Ed. Yeah, no, that is very interesting. But again, it all comes from the European Court of Justice's decision, which has to be respected. That's really the goalpost. It needs to be complied with. So that's why I said, at least at the public administrations in the EU, this is why there is one way to solve this issue is to say, okay, no more transfers. Very simple. Second way, obviously, is to go into the contracts, revise the contracts, make them, harden them, secure them, make them, as we call it in the house, Schrems 2 compliant, with extra clauses on no government access, information by the processor to the controller, compensation possibilities for unlawful government access, etc., etc. And a general, I think, reconsideration along the lines you said, and along the lines, do we really need to use that contractor? Do we really need to use that processor? Can we limit the outreach of our processing operations to some certain countries where we have believingly knowledge what happens actually in that country. So this judgment will have to be implemented, and there are some real world outcomes on this. But my impression is that in the general public and probably in the corporate world, it's not taken as serious as it is. So we will see a lot of change because of that. And for the adequacy decisions, we are not yet, we have given opinions on the new adequacy decisions for South Korea on the draft. But I know that, of course, the previous adequacy decisions are being reworked. They are being revamped to reach the level of the GDPR. So I can confirm there is work going on, but that is the European Commission indeed who has to do that job.
One last question on this before we move on to another topic. It sounded as, I mean, I understand, and obviously from the Schrems 2 perspective, the point of view has been and should be the data subjects and the impact on the data subjects, their lack of recourse. And Robin, you were mentioning that, you know, in the best of all possible worlds, the rights go with the data subject, and they should be able to exercise their rights wherever the data is stored. Obviously, that would be sort of nirvana. It isn't the way it works in all countries, at least not right now. One of the sort of alternatives to the standard contractual clauses and BCRs, where you cannot, you know, meet the Schrems 2 test, is we've been told use of the derogations. And what does that really mean? Consent. And we heard Sarah talk about how the Canadians thought about that, but discarded it because it would just not be, I guess, considered practical. Where are we coming? Are we coming full circle back to individual consents for everything? Is that the answer?
So, I mean, I would actually sort of give that question back to Thomas. I think at the end of the day, that's really something that the regulators, right, are going to have to determine, are derogations appropriate in this context, or are they, you know, not for regular, you know, data transfers that sort of happen during the course of business and provision of services, but rather for individualized instances. And I think that there's not a lot of clarity around that, and it's really a question that I think could be fleshed out.
I don't know if Thomas wants to pick that up or if anybody else has any thoughts.
I can offer some quick views as a citizen. I wouldn't want to be obliged to use consent for every single data transfer, especially if I know that the data being transferred is probably not going to be lawfully transferred because it's too much and too unnecessary. So I think from my perspective, I'd rather to see and use a service where I know that my data is handled in the proper way. And then you can use a contract, or you can simply limit it to certain areas in the globe. But honestly, I think we as individuals, we have better things to do than to individually consent every time there is a single data transfer. So I'm not very positive on this, especially since the derogations are derogations. They should never be used for normal commercial constant purposes. So I don't see that.
Yeah, I think if I may weigh in, some of the best, so Canada tends to be very consent centric, and it's created a lot of issues for organizations to comply because there are just some things we need to do as a business, which doesn't make sense to reach out to the data subject and ask for consent. And I think the light that GDPR has shown us is that there can be different legal grounds of processing. And the one that I really like the most is the legitimate business processing one. I think a really good approach is to flesh that out and to define it and to know what the limitations to applying that are. And I think in Bill C-11, they've tried to come up with something similar, which is called business operations. They haven't fleshed it out as well as it has been done in GDPR. But I think for like common day-to-day commercial processing, fleshing that out really makes a lot of sense because in so many situations, I don't think anybody, like the organization or the data subject, wants to go around finding out the nitty-gritty details of how every company is dealing their data.
All right, well, let me move on to another topic, which is, I think, equally challenging, which is the cookie metadata tracking, surveillance, profiling issue. I don't know, people look at it from different perspectives depending on what kind of provider you are and what sorts of activities are flowing from it, including government's access to that data, which is what we've just been sort of talking about. But moving to the actual collection and processing of this data for purposes other than providing the service. I'm just wondering, obviously the European Commission and institutions have been looking for 5 years at updating the EU Privacy Directive, and it's been highly contentious, and it remains so. It looks like Slovenia is not going to be able to make any progress any more than any of the other presidencies have over the past 5 years. So on the other hand, in the US, we have a new Federal Trade Commission, potentially a new approach to thinking about some of these issues, and also a new Federal Communications Commission or group of commissioners. So sometime we might have actual leadership with the new chair appointed, and if and when we do, maybe we'll see some action there. So I guess it does seem like all change in the US to some extent, but still in the works. And in Europe, it seems like a bit of stagnation because these issues of regulation are so difficult. What are the prospects for a reasonable solution, legislative or regulatory, in the US, the EU, and how are other countries dealing with these challenges? Anybody want to take that? Sarah?
I can start with just like a quick summary of what we've been doing in Canada, and then we can debate on whether it's right or not. So about a decade ago, the regulator released guidelines for online behavioral advertising. So that was like this big umbrella term for using personal data that is collected through pixels, IP addresses, any tracking technologies like cookies. And mostly they just seem to emphasize the need for express opt-in consent, just a lot of transparency and general adherence to the PIPEDA principles, accuracy, safeguarding the data subject rights, storage, retention, all of that. And I think that those were initially guidelines, though, to be honest, since we're federally regulated and the regulator tends to focus a lot of light on us and the general big telecoms, even though those were guidelines, on us, they were implemented. Like, no, you've got to implement them. They're not just guidelines. And now I see that a decade later, with all the legislative revisions going on, the need for express opt-in consent has made its way into legislation as well. So for example, in Quebec, and a lot of people say with the Quebec legislation that just passed in September, it's like GDPR has come to Canada. So they're saying that all organizations that collect information that can identify, locate, or profile an individual, they must by default, that must be deactivated by default. And Bill C-11 says something similar, that you cannot collect or use PI without knowledge or consent if it's for the purposes of influencing behavior or decision. So I think this really, they're trying to contain and kind of bring back digital advertising and marketing, and they're trying to shift that landscape a lot. So I still know that it's we're still a little bit behind what's going on in Europe, but at least that's what's been going on in the previous decade in Canada, the shift towards express opt-in for all of these technologies.
Maybe I chip in from the EU point of view. I mean, we actually have this, as you said, the e-privacy directive is a specific rule which sits on top of the GDPR, and that's why we're insanely waiting for the adoption of the new e-privacy regulation, which ideally should be totally aligned with the GDPR. What does that mean? I take it from two sides. We know that nobody, I think including us again, Nobody likes the cookie banners because you question how useful they are. At the same time, this is what the e-privacy rules say, and I think rightly, that before somebody puts any information or wants to read information from your device, you need to know what's going on and you need to be able to say yes or no. And at the same time, we have compelling evidence in numerous studies from numerous member states who have checked, for example, how the ad tech industry works and how absolutely non-compliant with the GDPR these practices are. So it's high time that we see an end to that. Nobody wants to be tracked. Everybody wants to be peacefully on the internet. I take a word from Robin on this. And that's why I think data protection by default, again, which is already an obligation under the GDPR, means exactly this. I can do what I like on the internet without anybody using and processing my personal data based on that. So no tracking by default. You find it actually already in the GDPR. It just needs to be translated now into the e-privacy regulation. And ideally, that is something which could be done, for example, by a browser or an extension or whatever, a plugin. So there are ways to signal your consent, if that still persists as the criterion, in a technologically useful and efficient way. But unfortunately, and as you know, as you've said it, the legislators in the US don't seem to agree yet. We'll have to wait, hopefully not too long, for a final outcome of this.
Can I give an intervention there?
Please.
Good.
Yes, we can hear you.
I'm glad to be back. I think consent in itself should never be used as a magic wand in order to process anyone's personal information. And I'm using the word a magic wand because, as we know, consent is not the Oxford English definition of consent. You know, they're different. So, you know, I'm very shy of saying consent should be the end that we should back to. I think informing data subjects of...
Sorry, Professor, we're losing you again. But I think we got the gist that. Oh, go ahead.
Key.
All right. Well, I think the point was basically that you're breaking up a lot, Professor. I think the gist was that consent is not the silver bullet, and we need to find other approaches. We've got about 8 minutes left, and I thought, you know, some of the very interesting points that Thomas raised at the beginning about the work that the Data Protection Board is doing on AI, and also digging into some of the technology so that there really is an understanding of the complex workings of both the technical aspects and presumably the business models around them. I thought we could maybe also expand this sort of question about profiling, surveillance, and looking towards the future, considering how this will work in a world where AI and beyond machine learning becomes, you know, a more advanced approach to everything that we do, given, as you know, I think Sarah raised the whole IoT issue, and you know, when everybody's coffee pot is, you know, sending back instructions or information about how long you're using it, how long you left the coffee pot on, you know, how much you drank, et cetera, and every other little tiny aspect of our lives. You know, what is that going to mean in the future? So looking ahead 5 or 10 years, maybe everybody could spend just a minute or so of, you know, where do you see this going? Where are we heading? Let's give Thomas the last word on that, and Professor Sizwe. Sarah, do you want to kick us off on that?
Yes, I think that so like in the next 5 to 10 years, I'm not exactly sure how the internet's going to change, but I do think that we're going to start seeing more biometric data. So right now we're using, you know, maybe thumbprints or like voice recognition to give people access to, say, the office. I think that in 5 to 10 years, that could really be like iris scans. So I think the sensitivity of that data is also going to increase a lot. And with that, of course, we need to have very specific guidelines on the use of biometric data. I mean, it's one thing to say that we can just classify as sensitive, but maybe on top of that as well, it's not exactly being, I mean, biometric data is sensitive health data, but at the same time, it's not being used in a health setting or in the medical setting. It's being used in the commercial setting. So I think we need to have some specific guidelines around that. I know in Canada that they have started building those guidelines out, but right now they're only talking about facial recognition in the use of law enforcement. Whereas I think in the commercial and the corporate setting, like a lot of companies want to use that beyond the law enforcement setting. So I think that, I mean, kind of as usual, companies are using that data, and regulation needs to catch up and see how and whether they can use it and under what circumstances.
Thank you. Ivana?
I would sort of mention three trends that I think at least I see in the next 5-10 years. One, I think, is the importance of the EU influence on digital policies. And we saw that a few years back with GDPR, and I think we are seeing that with AI, the work that the EU is doing on AI. So I think that's a space that we all need to watch, and how that influence is extending beyond the EU. The other trend that I think we spent a lot of time discussing was the risk of fragmentation and data localization and protectionism. I think that's a very worrisome trend. And on the positive side, just to end my remarks on a positive note, I think concerns about society and ethics are becoming more important for everyone, for policymakers and for companies. Human rights that Robin mentioned, sustainability, diversity, equity, and inclusion. I think those are being incorporated into all the policy discussions. And I think that's a very positive trend in our space.
Thanks, Ivana. Robin?
Thanks. I'll start on the positive trend and just plus one everything that Ivana said on the positivity of sort of how we're now seeing human rights and sustainability and diversity really incorporated into not only the general policy debates, but also the regulatory discussions, and actually oftentimes being accounted for in drafting in various ways. But I do think that internet fragmentation is really the trend that worries me most. I think, you know, it's hard for me to look at 5 to 10 years out and imagine what kind of internet we have. If we continue on the path that we're on right now, I don't think that we'll see a globally connected, interoperable internet that really allows people and businesses and governments to manifest all of the progress and potential that kind of interconnection can empower and enable. But I do worry a lot about data localization, of course, but I would be remiss if I didn't also mention concerns about, you know, the trends that we're seeing with respect to how governments are treating encryption. Encryption is one of the most important security and privacy and free expression tools that individuals have. And the reality is that we're seeing increasing attacks on encryption all over the world, including in many jurisdictions, you know, where that might be surprising based on other sort of human rights records. And so, you know, one of the things that I am concerned about from the internet fragmentation perspective is where you have sort of portions of the world that can securely communicate with one another and engage with one another and access information and so on and so forth. And then entirely other portions of the global population that are cut off from secure communications technologies. And just as suspending data flows limits one's ability to exercise their fundamental rights to the fullest degree possible, so would limiting access to encryption by requiring exceptional access, commonly, colloquially, I should say, known as encryption backdoors, or other phenomenons that we're seeing now, such as requirements to have access to content in encrypted systems so that you can engage in content moderation and traceability requirements. At the end of the day, those kinds of requirements break end-to-end encryption, or at the very least sort of break the promise of and the purpose of encryption. And so they're not reasonable, they're not proportionate, they're extremely dangerous. And like data localization, they do drive internet fragmentation. My hope is that this can be resolved by governments, especially like-minded governments, working together to really develop what a harmonized approach to government access to data flows, and to data protection and privacy looks like. And at the very least, starting to think about what do more innovative approaches for adjudicating conflicts of law look like in the digital space. I don't think we have good international legal mechanisms to help resolve those conflicts of law. And ultimately, it's the internet user that is going to suffer the costs of these conflicts, less than the governments themselves.
Thomas, sorry. Oh, you're back. Great, very good, Sizwe.
No, I've been here. I just switched off my camera.
Excellent. We have 1 minute. 1 minute for you and 1 minute for Thomas.
I'm saying the conflict between access to information, in other words, access to the internet, like the struggle I've had today with connecting to this discussion, versus the discussion of privacy, I think is the discussion that one needs to have in 2021. You know, with the advent of COVID-19, we've discovered how badly we have access to internet / access to information, because I always say the internet now has become a secondary right of the access to information. But within enjoying this right, we need to have adequate safeguards either by the states or from the data processors and controllers or whatever third parties that process our personal information.
Thank you. And last word to you, Thomas.
Thank you very much. I agree with my panelists. We'll see an explosion of interconnectivity and an explosion of processing of personal data in the coming years. But that means also we shouldn't forget technology is a tool. Innovation versus protection is a false discussion. We need to be able to say we want certain technologies to thrive, but we want them to thrive in a way which is compliant with human dignity and our values. Because otherwise people won't trust it. And if people don't trust in that technology, they won't be using it. It's very simple. That's one thing. And the second thing is we'll see a big discussion on enforcement, because as we know, as lawyers, a law which is not enforced is not a good law. So we as the EDPS will be hosting a conference next year on efficient enforcement of the GDPR and of the digital world, because we see with the EU's rules on artificial intelligence and the Digital Market Act, etc., that enforcement will be key. And that's not just data, that's not just on data transfers. This is actually on screening of incoming data into the EU. If you read the AR regulation, it's a square decision of the EU to say we don't want any data in the EU which hasn't been processed in the way we'd like it to. So we're looking into data quality screening there, and that is potentially very interesting. So thank you very much for the conversation.
Well, thank you all. And I think the IIC, you know, at least in a sort of private forum like this, at least gets the discussion going. I hope governments will also start to discuss these issues. Maybe California, EU, you know, maybe we'll have an adequacy decision there. That would be great.
My vote is for EU-US.
Well, we could start with California. Baby steps, right? But in any event, thank you all to the panelists. Excellent discussion. And over to you, Lynn.